Welcome back to the Emily Show. Last week was a week off for spring break. This week, there is much to cover and a little bit of travel. So you know what that means. More is going to pop off this week. There are so many new filings in many of the cases that I'm covering. We are only going to get to an overview, hair's breadth of most of them. I hope that there will be deep dives coming, but it's really going to depend on what happens with the Karen Read trial, because that is a little bit up in the air due to what Judge Cannoni said in court. So today we need to talk about the new filings in the Karen Read case, because I called some of what was going to happen. And if you have not been watching the streams, you have missed a lot in that case, especially if you've not seen some of Karen Read's latest statements to the media. I said this is where Brennan was going to go. And guess what? He sure did. Drake is not just losing a rap battle, but getting epically shaded by his own label in their latest legal filing. And we're going to have to take a peek at that. Tons and tons of filings in the Bryan Kohberger prosecution in Idaho, as it's also getting ready to argue the motions in limine. Those are the motions we've been covering in the Karen Read case, those pretrial motions. They're getting ready to get started in oral argument in the Kohberger prosecution. I will be covering those live. And then lots of filings going on in the lively Baldoni of it all. And I'm going to tell you what's being filed and what the next step is. And we'll do a deep dive into, well, Emily, every single one of these filings is like 50, 60, 70, 80, 100 plus pages. We will talk about those motions to dismiss in a future episode in more depth. So that's a lot on the docket. We should just get into it. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. For all of you watching on YouTube, again, welcome. Don't forget to do the YouTube-y things on the Quick Bits channel where the podcast lives, but also there are timestamps down below, so you can always find the topics that you are looking for as fast as possible. Because even though the Emily Show podcast is quicker than a stream, it's not your average content here. It's way more than that. Let's talk real quick about everything that's going on in the Baldoni lively cases. Remember, there are still multiple federal lawsuits between a wide variety of parties. Of course, the main case is Lively sues Baldoni et al. Baldoni sues Lively, Reynolds et al. And then those cases got consolidated. So it is multiple lawsuits, but all in one case. So those are tracking together. So the New York Times is now part of that federal case, and most of the parties are lumped into those two litigations. For a lot of the parties, they are both plaintiffs and defendants at the same time in those cases. Then there's also the Leslie Sloan PR litigation, where she sued Baldoni, Wayfarer, and the other PR agents. Wayfarer has now countersued her in their own federal case, but they are still also tracked into the main set of cases. So when we're looking at how many federal cases there are, there's a multitude of them, but there is one main case and then like 3 satellite cases at this point. In the main lively Baldoni litigation, the New York Times has filed their motion to dismiss, and that's just at the end of briefing. I'm very curious to see if the court is going to set these motions to dismiss in like subsequent hearings to just go through all of the arguments at once. For the Baldoni parties, it's all the same attorneys arguing them, so it might make sense to consolidate those. So there might just be some big days of motions to do these motions to dismiss. But the briefing on the New York Times motion to dismiss is just about done because the reply just came in. Then we had motions to dismiss filed by Ryan Reynolds on March 18th. Blake Lively filed hers on March 20th. Jed Wallace and his company Street Relations filed their motion to dismiss on March 19th, and Leslie Sloan in this group of lawsuits filed the motion to dismiss on March 13th. So there are a bunch of motions to dismiss still pending, and we're waiting on oppositions and replies for most of them. Remember, at the motion to dismiss stage in these civil lawsuits, we are looking at whether or not a claim has been stated. Can this case on the bare bones go forward? Have you stated a claim? So these motions to dismiss, though some argue nuances in the law, like the Lively motion to dismiss argues a nuance to California law, argues the choice of law provision in California, allowing California law to be argued and saying that she can't be sued by these parties because of changes to California law in this workplace harassment lawsuit. Most of the motions to dismiss are saying, hey, in this filing, you did not state a claim that someone can be sued for. When motions to dismiss are granted, the thing that generally happens the first and sometimes the second time is that the other party gets leave to amend. So when these motions to dismiss go through their litigation, even if they are granted, it is exceedingly unlikely that at the first motion to dismiss stage that any of these lawsuits are going to be terminated in their entirety. I have said that in the Baldoni lawsuit, there are some causes of action that are pled only to some parties, but then they name all the parties. I think those things will be pared down, but I don't think the motion to dismiss stage is where we're going to see any of these lawsuits terminated because, again, there is always an opportunity to amend, and it's exceedingly unlikely that a motion to dismiss at this stage in any of these proceedings will be granted with prejudice and not allowed to be brought again. We are not at the summary judgment stage. That's way down the road. And these motions to dismiss, again, look at the lawsuit. In the lawsuit, did you say the legal words that comports with a defamation suit or any of the other causes of action? And did you say the other person did it? It is a very minimum beginning to litigation. So we'll go through those arguments, but a lot of it is more shade. And since the shade in the Drake UMG lawsuit is A, not exhausting yet, and B, kind of hilarious, and C, the filings are shorter, we're going to talk about that a bit more today. Say, Drake, how mad are you at UMG now? Because man, oh man, this lawsuit has popped off. I covered towards the end of last year the first rumblings of Drake suing his label UMG over Kendrick Lamar's song Not Like Us, way ahead of the Super Bowl and the rest of it. And at that point in time, it was a lawsuit is coming and we want to get discovery. Since then, Drake filed the lawsuit and UMG just filed their motion to dismiss. What I find really interesting about UMG's motion to dismiss is some of the principles in law that they are arguing. They are going to be arguing things like hyperbole and opinion when looking at a defamation suit. But to make sense of all of the shade in the UMG response, we need to take a look real quick at what Drake filed. And he filed this lawsuit on January 15th, 2025. The causes of action here are defamation, harassment, and violation of New York business laws. It is an 81-page filing. We are not going to go through all of it, but Drake does take quite a lot of time, and I'll attach a link to the filing down below if you would like to read it. But Drake takes quite a lot of time explaining Kendrick Lamar's lyrics and why they're directed at him, which is a real interesting way to go. Like if you have to explain to the audience why it's about you, it might be difficult in a defamation case. However, Drake also does point out quite a lot of comments of what people are saying about him on social media. So his lawsuit goes a long way to scorch himself. And at points of the lawsuit, he breaks down Kendrick's lyrics line by line and sometimes frame by frame in the music video, explaining why the piñata of an owl is a shot at him and more. But again, if you have to explain it, is it clearly defamatory? And I think that's an interesting question. So in the Drake versus UMG recordings defamation suit, the complaint at the introduction stage starts with a quote from Sir Lucian, and I think it is Grange. And if you're being like, Emily, Lucian, no, we are not in the SJM universe. We are talking about the head of UMG. I know he's been in other lawsuits. Every time we say Lucian, I'll be in the comments. We'll chat about the books together. Don't worry. But the introduction of the lawsuit starts with a quote that says, quote, "A single lie can destroy a reputation of integrity. And while it takes years to build a reputation, it can be ruined in 5 minutes." Sir Lucian Grange, CEO of UMG, March 25th, 2024. It goes on to say, in the middle of the night on May 7th, 2024, an armed group of assailants drove up to the Toronto house in which Drake and his family resided. Drake was inside. The car stopped in the front of the residence. Someone yelled, "Fuck Drake," and at least one gunman began to open fire. One bullet went through the security gate and hit Drake's front door. That is how this defamation suit starts. It starts with Drake talking about the real world, he says, consequences of UMG publishing Kendrick Lamar's song, Not Like Us, and supporting that song as it topped charts, etc. He goes into the rest of this lawsuit to explain those lyrics, talk about the damage to his house, and he talks about the fact that the Not Like Us single has cover art that is Drake's house with pin drops that look like the pin drops from a sex offenders registry, and the fact that the song image on Spotify and Amazon Music also have that cover art. And in that cover art, it has the street name of where Drake lives. And again, the like Google Map overview of the house, and then like 15 little images of those pin drops. So Drake ties back UMG publishing this cover art to some of the threats and violence experienced at his house. They say in the lawsuit that the image features an aerial view of Drake's Toronto home, including identifying information regarding the location of the home, and is covered in the icons used by law enforcement and public safety applications like Citizen to identify child sex offenders and their residences on public registries. As of the date of this filing, UMG's original publications of the recording and images remain available on the aforementioned platforms. This lawsuit continues to talk about the things in the music video and tying UMG back to publishing those things, even though what was said and the imagery used were determined by Kendrick Lamar and whoever the creative team is. So when UMG responded, they responded in like fashion. In UMG's motion to dismiss, filed on March 17th, they also open up with a quote. You know, lawyers are going to take the opportunity to be petty, and here that's exactly where we're at. Quote, "Yeah, I want it all. That's why I strive for it. Diss me, you'll never hear a reply for it." Drake from the song Successful. So in the opening salvo to the motion to dismiss, UMG says, "Oh, you want to play quoting games? Okay, we'll just quote you." Throughout the entirety of the motion to dismiss, the legal heart of the motion to dismiss is that this was a rap battle and it includes outlandish insults that are opinion and that are not stated as fact. And they make that point fairly finely in the following paragraph. Quote, "Plaintiff, one of the most successful recording artists of all time, lost a rap battle that he provoked and in which he willingly participated. Instead of accepting his loss like the unbothered rap artist he often claims to be, he has sued his own label in a misguided attempt to solve his wounds. Plaintiff's complaint is utterly without merit and should be dismissed with prejudice." Remember what I said about motions to dismiss. It is unlikely that a motion to dismiss will be granted with prejudice at this stage. That generally happens much more in the motion for summary judgment stage because courts often allow plaintiffs at least one, if not multiple opportunities to amend the complaint unless there is a true legal sufficiency issue where what is being alleged can never be brought in a civil claim. The introduction lays out what a rap battle is, saying in the spring of 2024, two of the most popular recording artists in the world, Kendrick Lamar and Aubrey Drake Graham, Drake or plaintiff, engaged in a high-profile rap battle. Over the course of approximately 2 months, they exchanged increasingly vitriolic and incendiary diss tracks, in quotes. Explaining diss tracks to a federal judge, by the way, is just 10 out of 10. Sometimes responding within hours of each other. Drake encouraged the feud. For example, when he felt that Lamar was taking too long to respond, Drake released a second recording in which he goaded Lamar to continue the public rap battle. Lamar did just that, and collectively, Drake and Lamar released a total of 9 tracks taking aim at each other. Multiple commenters declared Lamar to be the quote-unquote winner of the battle. Not Like Us, the penultimate track in the feud, is the subject of the complaint. The recording and the music video were released by Lamar through defendant UMG on May 4th, 2024. Not Like Us was a massive commercial and artistic success. The record was the best-selling rap recording of 2024 and won the Grammy Award for Record of the Year, and the accompanying music video won the Grammy Award for Best Music Video. They're going to go on and double down on how great Not Like Us is, including winning a Grammy Award for Song of the Year, becoming a ubiquitous cultural phenomenon. Among other things, Lamar performed the song at the 2025 Super Bowl halftime show to a record audience, and Saturday Night Live parodied it for its recent 50th anniversary special. Yeah, because Say Drake is iconic.
Say Drake, I hear you like I'm young. You better not ever go to Cell Block 1.
Not only that, but it spurned like the best marketing campaign ever for Duolingo, because Say Drake with the grin to camera immediately became the thing of social media marketing dreams. When it even is discussed by me outside of the lawsuit, we have reached full cultural purveyance. Not Like Us, like all of the recordings in the feud between Drake and Lamar, and like many notorious diss tracks throughout rap's history, consists of a series of hyperbolic insults. Drake has been pleased to use UMG's platforms to promote tracks leveling similarly incendiary attacks at Lamar, including, most significantly, that Lamar engaged in domestic abuse and that one of Lamar's business partners and managers is the true father of Lamar's son. But now, after losing the rap battle, Drake claims that Not Like Us is defamatory. It is not. While the complaint focuses almost entirely on Not Like Us, it disregards the other Drake and Lamar diss tracks that surround Not Like Us, as well as the conventions of the diss track genre, and thus critically ignores the context of the dispute. And oh boy, do they go on to lay out what they are saying is context. But I think what is interesting about this lawsuit, not only that an artist is suing their own label, that happens, but an artist suing their own label for defamation over what another artist said is something I don't know if we've seen like this. And they go on to say that in context, Not Like Us clearly conveys non-actionable opinion and rhetorical hyperbole. Diss tracks are a popular and celebrated art form centered around outrageous insults, and they would be severely chilled if Drake's suit were permitted to proceed. And it's an interesting question is, in this genre, which they were clearly participating in, when is it considered hyperbole? When is it considered over-the-top bombastic insult? And when is it considered allegations of fact? Because for defamation, it has to be a factual statement. And do people take it as factual statement? Or are they hyperbolic insults that pick up on what people are already saying? And is that defamatory? Is it not defamatory? UMG goes into line out things said back and forth in this rap battle and insults exchanged by both artists saying, look, we published all of the songs in this feud because we represent both artists. Do you think UMG took a side, or is UMG's side like, we're making money? Keep publishing, everybody. You're doing amazing, sweetie. Look at how much everybody's talking to everybody in the ecosystem. We got both sides of this feud. They go on to use Drake's words against him more, saying notably less than 3 years ago, Drake himself signed a public petition criticizing, quote, the trend of prosecutors using artists' creative expression against them by treating rap lyrics as literal fact. What now? And this is a huge conversation. We talked about this more in the YSL case, is when can rap lyrics be used? When can rap lyrics not be used? When should they or should they not be used? Are they factual retellings of events? Sometimes they might be. Are they hyperbolic? Are they bluster? Are they posturing? Where is the boundary between what is an art form versus what is a retelling of fact? And Drake coming out saying that rap lyrics being treated as literal is a problem. Will that be problematic for him before the judge on the motion to dismiss stage? Maybe not. Will it be problematic for him when and if this goes to a jury? Maybe. Can you imagine being on this jury and having the lawyers get up and be like, okay, say Drake, like explaining this rap battle in an opening statement would be imminently entertaining. UMG goes on to say that as Drake recognized, when it comes to rap, quote, the final work is a product of the artist's vision and imagination. Drake was right then and is wrong now. The complaint's unjustified claims against UMG are no more than Drake's attempt to save face for his unsuccessful rap battle with Lamar. The court should grant UMG's motion to dismiss the complaint with prejudice, meaning it can't be brought again. They're saying basically, really? This is what you're doing? You lost. Stop it. UMG then goes through the timeline of this rap battle and quotes Drake's first song, Push Ups, in April 2024, and then says, quote, then seemingly impatient with the time it was taking Lamar to respond, Drake released Tailor Made Freestyle on Instagram. The recording used artificial intelligence to make it sound as if the voices of the deceased rap icon Tupac Shakur and rapper Snoop Dogg are rapping Drake's lyrics. Emily, make a note to self. Has Tupac's estate sued over this yet? Has Snoop said anything about this yet? I truly don't know. It's on my list because we are seeing artists confront the issue of AI voice usage in a whole different way. I had a conversation with Sir Mix-a-Lot about it on the podcast ages ago, and I will link that down below as well. But this is an issue for artists when their voice can just be grabbed by AI and generated to say anything. And it comes up again in some of Kendrick Lamar's lyrics being like, do not invoke Tupac. Like, you've outraged the West Coast. It goes on to say that Drake taunts Lamar for the delay. More notably, for present purposes, Drake urges Lamar in the voice of Tupac to, quote, talk about Drake liking young girls. You said what now in your song? So in your song, taunting Kendrick Lamar to reply, you said, why don't you talk about Drake liking young girls? And are suing, saying that that's defamatory now. I wonder how a jury's going to feel about that. I want to know how you feel about that. Let me know. They quote the lyrics saying, in part, we need a no-debated West Coast victory, man. Call him a bitch for me. Talk about him liking young girls. That's a gift from me. Heard it on the Budden podcast. It's got to be true. That's what the lyrics said. How's that going to play? When you tell someone to talk about a thing, A minor, and then turn around and sue them for saying the thing. And because lawyers are lawyers, they took another entire section of this lawsuit to talk about the massive commercial success of Not Like Us, just to rub a little salt in the wounds. There was also the element of actual malice. UMG goes on to state, quote, much like parody and satire, hyperbole, exaggeration, and insults are endemic in rap, particularly in diss tracks. Rappers know that their lyrics are exaggerated and non-factual. That is part of the craft. The actual malice question is therefore what UMG intended to convey, and Drake has not alleged any specific facts plausibly evidencing in a clear and convincing manner that anyone at UMG intended to convey or indeed believed that the public would understand Not Like Us as conveying anything other than what it is, an incendiary diss track. There are some really interesting questions here of where the boundaries are for defamation, of where the boundaries are when you sue the publisher rather than the speaker. And I think we're also going to see a ton of lawyer sass, which I appreciate. Look, UMG responded in kind to the way Drake's attorneys wrote this lawsuit and went through with the words Drake said and called out other tracks where Drake was making direct threats and said, okay, well, he's threatening to kill somebody. Are we to take that literally? Like, where is the boundaries of what is to be taken literally and what is known to be exaggerated? So, I'm going to do my stuff. And again, Not Like Us is a bop. So I'm sorry, Drake. UMG said that your feelings are hurt and wants this case dismissed, but it's probably going to be in litigation for a little while longer. I'm going to keep an eye on it. The questions of parody and insult and where the boundaries are within specific categories of speech and art, I think is a really interesting topic to follow. And I don't know if we've seen a lawsuit quite like this. So we're going to keep an eye on it. And moving back into cases that I'm going to be covering more in court in the coming weeks, we need to talk about the Bryan Kohberger prosecution in Idaho. Thank you to today's sponsor, OneSkin. You know I love sharing with you things that keep it simple, and OneSkin is 100% that. OneSkin is scientifically backed skincare that really is a topical supplement that keeps your skin healthy as you age. Founded by an all-woman team of scientists, OneSkin is the first and only skin longevity company to target cellular senescence which is a key hallmark of aging. And they target that with their OS01 peptide, which is scientifically proven to decrease lines and wrinkles, boost hydration. We love being hydrated, don't we, law nerds? And help with thinning skin that often comes with age. But don't just take my word for it. OneSkin's products have over 4,000 5-star reviews, and they have face, body, sun, and travel size products. OneSkin focuses on the cellular aspects of aging and keeps your skin looking and acting young for longer. Get started today with 15% off using code LAWNERD at oneskin.co. That's 15% off at oneskin.co with code LAWNERD. And after your purchase, they will ask where you heard about them. Be sure to tell them that you found OneSkin through The Emily Show. It's time to invest in the health and longevity of your skin with OneSkin. Your future self will thank you. Let's get back to today's episode. You have probably seen the headlines because a ton of motions in limine and now some of the replies to the motions in limine have been coming in the Idaho case. And the audio for the 911 call in the Kohberger prosecution has been released. I'm not going to play it in this podcast. I am going to link it below. It's heartbreaking. It's going to be questioned in court. There's room to question it. I talked about what I thought those questions would be when we looked at the transcript of it. The individuals who are speaking on the 911 call, and we hear multiple individuals passing the phone around, they're going to be questioned at trial. So we will hear more about what their state of mind was at trial. And at trial, there are going to be questions about where in the gap of time between the text messages of the roommates being concerned about something happening and the call to 911 the next afternoon. All of those things are going to be addressed pretty thoroughly in trial. So I'm not going to speculate on them here. What was notable to me about the 911 call is it seemed some of the individuals on the phone weren't quite sure what happened and were going off of the fact that the roommates had been non-responsive on the phone, like we're not responding to them. But it seemed to me from the language used and the manner of distress that the callers are in that they had not gone and physically checked on or seen their roommates yet. That was what I took away from it. So I will link that below if you want to listen to the 911 call. It's notable to me that the 911 call is only about 3 minutes long. It goes out at 11:55 and 42 seconds a.m. local time. And the callers note that law enforcement is at the location at 11:59:49 a.m. So law enforcement arrives on scene incredibly quickly. And then we will see, I think, that 911 call in its entirety played in court. And we will see the speakers on that call questioned about the call, what they saw. And then because that call is only about 3 minutes long, I imagine we will also see in trial body cam footage of those initial responding officers and what they uncovered as they came into the house, who they interacted with, the state and demeanor of the parties that were in the house on the 911 call, and more. So this is going to be the subject matter of at least one of the motions in limine about whether the 911 call comes in, whether it comes in full, how it comes in. I think we will see the audio of it. We also are going to have motions in limine argument over descriptions of Bryan Kohberger as someone with bushy eyebrows and how will the bushiness of a brow be determined. But those descriptors were made by a live witness that's going to testify in court. And so they're going to ask that witness, what do you mean by that? How do you match that description? And we've seen prosecutors actually ask now to bring in a selfie that they recovered from Bryan Kohberger's digital devices that was taken about 6 hours after the murders. So prosecutors are saying, look, this photo is from close in time to when this happened, and the jury gets to decide if that is an individual with bushy eyebrows or not bushy eyebrows. There is also going to be more fighting over Bryan Kohberger's use of Amazon. And we knew that this was coming. We weren't sure what he purchased or didn't purchase or looked at on Amazon, but there was quite a lot of fighting over keeping the Amazon information out because of the search warrant. And that was all denied. We talked about that and covered those hearings on stream. But we now know from prosecutor motions that Bryan Kohberger did purchase a K-bar knife, a knife sheath, and a sharpener in March prior to the November homicides. And we know from the prosecutor's filing that they are saying he was also searching for that knife after the homicides. So his computer activity and phone activity is going to be one of the central things in this trial. And of course, we know that a K-bar knife sheath was left at the crime scene and has Bryan Kohberger's DNA on it. So the defense is going to have to argue that that got there a different way. I think that the arguments over the motions in limine, and there are dozens of them, will probably take about 2 days. Those are scheduled to start on April 9th. If you do not have the Law & Order app and you do not want to miss these hearings live, go ahead and get the Law & Order app at lawandorderapp.com, because I will be covering all of those motions in limine hearings. And I expect we will see at least an inkling of which way Judge H is going to go on those based on his questioning. He is a very active questioner of the parties. The defense has asked for witness testimony during the hearings, and that has already been denied by the court. So it will likely just be argument from the lawyers on their moving papers, on their filings, and there are quite a lot of them. But we will talk about those a little bit more as we get closer to that April 9th date. But before we go back to court in Idaho, we will be back in court in Massachusetts for another court date in the Karen Read case. We are still waiting on rulings from the court in that case, including a ruling on the motion to dismiss. It seems that there, well, is precious little time for there to be a evidentiary hearing on the motion to dismiss, though I think that there should be based on all the argument that we heard. Maybe there still will be, but what the court said last week is that on the defense's motion to continue, where the defense asked to put off the start of the trial till April 28th, the court said that she was not inclined to grant that continuance. However, the court did say she wanted to start picking a jury, and if the jury was selected before the March 28th date, then she would entertain waiting to start the opening statements and the evidentiary portion of the trial until the 28th and not swearing the jury in yet. So it was really a compromise on behalf of the court. I think the court anticipates that picking a jury for this one's going to be really hard, and I'm not surprised. Truly, there's been so much media attention, especially locally, on this case. And with the first trial, I'm sure those that are local, even if they hadn't been paying attention to the case, might have tuned in once it went to trial. So trying to find a jury in a high publicity trial is always a little bit difficult. But trying to find a jury for a high publicity retrial is on another level, because a lot of people locally are like, oh, I hadn't heard about this, but what's happening now? And this case, even though it has gained national attention, has very, very intense local attention. So I don't disagree with the judge here that picking a jury could take 3 weeks. And so the motion to continue doesn't really need to be granted. However, it doesn't give all the attorneys as much time to work because they're in court all day picking a jury. I have to wonder if the defense asking for more time was a double-edged sword for them, because what we saw in the last hearings of last week that I streamed on Thursday were that the prosecution had been granted conversations, or what if any conversations exist, between Karen Read and blogger Turtle Boy Aiden Carney. And whether or not those exist or don't exist, the government has his phones and downloads from numerous of his phones in the cases they're prosecuting against him. In 2 of those phones, they have cell phone extractions, and the prosecutors in the Karen Read prosecution were granted access to any conversations between Turtle Boy and Karen Read. Now, we have seen Turtle Boy make statements that all of their communications happened in Signal, and those are encrypted, and those don't show up on all the phone records that the government has. So it might be a whole big nothing burger, but the government has more time to go through the conversations that were turned over to them. But the government is going after a lot more conversations, and this is expected by me, but wild. I told you all last week when we started talking about the new Discovery ID docuseries that statements made by Karen Read in this retrial are going to be used by the prosecutor. And the Discovery ID series follows Karen Read and her defense team during the last trial. And we've seen other interviews that happened around that same time period with similar statements by Karen Read. The prosecution is saying, look, Karen Read said all of these things. Give me her conversations with attorney David Yannetti. Give me all of the unaired interview footage with Karen Read and her attorneys. And there's going to be a discussion about whether or not Karen Read opened up some of her conversations with her lawyers based on statements that she made in the docuseries. which when I saw her making those statements, I was like, oh, well, the prosecution's going to argue that Karen Reed going on TV and saying, my attorney told me XYZ, opens up those conversations. And under attorney-client privilege, it might well open up those conversations. Do I think that that's going to open up every conversation ever had between Karen Reed and her defense team? No, but it can open up some. And that's exactly what the prosecution's trying to do. Let's take a look at this latest filing. Filed on March 21st by the Commonwealth, this is the Commonwealth's motion to compel communications between defendant and attorney Yannetti stored within the defendant's cell phone. Remember, they have Karen Reed's cell phone, but a taint team removed things that were privileged communications. The Commonwealth is now asking, hey, those conversations, we get those now. Well, I guess they're not asking, they're arguing that they are now entitled to them. So what exactly are they looking for? Well, the Commonwealth seeks all texts, emails, or written communications between defendant and attorney David Yannetti restricted to communications that occurred between January 29th and February 2nd, 2022. The privilege holder, Karen Reed, has waived her attorney-client privilege with attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29th through February 2nd. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. The Commonwealth goes on to cite Massachusetts Rule of Evidence 523 that talks about the waiver of privilege, and a privilege holder can waive the privilege. Who can waive the privilege, when the privilege can be waived. We're going to get into the statements that he says are the statements that open up the attorney-client privilege here, but there is a footnote about how he's asking this to be carried out, which I think is a reasonable request because he's asking the court to review this in camera and then the court will decide what to be turned over. For those of you that have no faith in this judge, that's not going to be very helpful, but it is the proper ask to either have the court do it or the taint team do it. The footnote says, to ensure that only the communications that were waived are provided, the Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone data for the time between January 29th and February 2nd. I think this should go to the taint team. I don't know if the court needs to be reviewing all of those, and I think the court should then review what the taint team does before it goes to prosecutors. We'll see what the court chooses to do here. These are the examples that the Commonwealth cites. They say in the defendant's recorded interview with Gretchen Voss on June 20th, 2023, the defendant concedes. Question from Gretchen Voss, you say, did I hit him? I hit him. Answer from Karen Reed, I said, did I hit him? And then, when I talked to David, now this is later, David said, quote, Karen, if you incapacitated him in any way, there's culpability there. And that goes to count 2. We've talked about that in other content. The quote from Karen Reed goes on to say, and I thought, all right, maybe this is what, maybe I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? That's the end of the quote provided by the Commonwealth. The Commonwealth then says that attorney Yannetti, Jackson, and Little were all in attendance with Gretchen Voss for that interview. They then quote the Vanity Fair article titled Karen Reed Tells Her Story Part 1 with a caption saying, quote, as Karen Reed's second murder trial looms, she's ready to talk about what she says really happens. Published on October 29th, 2024, the defendant, who according to the publication was, quote, notably aware that anything she said could be used against her, and volunteered a rumor that alleged representations made by the Massachusetts State Police that there is a text message between her and counsel that implicates herself in a provable lie. I don't even know what any of that sentence means. I don't. What in the world is Brennan even saying here? I don't know what the quote is from the argument. I don't know what a rumor is that Massachusetts State Police have a text message between her and counsel that implicates her, or that text message existence is a provable lie. What? But a bit more clear are the quotes from the most recent investigation discovery series titled A Body in the Snow, the trial of Karen Reed. Defendant professes, quote, "And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about things for 3 days. The Commonwealth then goes on to argue also the defendant's admissions that Attorney Yannetti's statements are relevant to challenge the defense's later purported claims of third-party culpability. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that part of its defense is likely to propose a Baldoni-type defense, which we have now seen play out in court, which I think they would have known when they wrote this motion because this was filed after that day in court, but maybe it was written before that hearing. But the defense is bringing in a lack of thorough and substantive investigation, which falls under that Baldoni-type defense. So the Commonwealth goes on to say the potential evidence is relevant to rebut claims of law enforcement contrivance. So what we're getting from the Commonwealth is we now get to get into statements made between Karen Reed and David Yannetti, if they exist, via text, email, or other written form in her cell phone dumps, where she's talking about whether or not she has an element of culpability. Though in these interviews, it seems consistent that Karen Reed says that she was talking to Yannetti. So does she mean a verbal phone conversation or does she mean a text conversation? And that in those conversations, she was running through, what if this happened? What if that happened? What if this happened? And if Yannetti said, well, if those things happen, there is culpability there, they want to bring that in to say, hey, at the time, close in time to this accident, before anything else happened, Karen Reed's first thought were, could I have done something? I don't know how far that will go with the jury at the end of the day, but it might undermine some of their arguments, or it might change some of the arguments they make. It's going to be interesting to see what the court decides to do with this, and if the Commonwealth gets into this in any way that's effective. But this really all goes to me towards count 2, whether there is some type of culpability on that lesser charge, not intentional. Notice Yannetti in any of these retellings from Karen Reed, he doesn't say, well, you're probably going to get charged for murder. He says there might be some culpability there, which again, all goes to count 2. Could Karen Reed's statements about what her attorney told her open up the Commonwealth's access to conversations in that time period about her own culpability? Yes, it can. Disclosing, I asked my attorney this and my attorney told me that, can waive your attorney-client privilege. Why make those statements with your attorneys there, not saying, yo, stop? I don't know. But when I said the Commonwealth is going to go after everything she said in interviews, it seems that that is where a lot of the focus is for the Commonwealth right now. And of course, to be thorough, the Commonwealth would also like the entire unaired, uncut, unedited, raw interview that Karen Reed had with anyone from the production of the latest ID Discovery docuseries. I said this was going to get filed. Here it is. March 21st, Commonwealth's motion for records, unsolved productions. Because of course that's what they're looking for. In their motion, they say, quote, on March 17th, March 18th, March 19th, investigation discovery, and HBO Max aired a 5-part docuseries entitled A Body in the Snow, the trial of Karen Reed. The aired docuseries is approximately 4.5 hours of a quote-unquote behind-the-scenes look at the defense team as it prepares for the April 2024 jury trial and features extensive interviews with defendant Karen Reed, attorney Alan Jackson, attorney David Yannetti, and attorney Elizabeth Little. They go on to say Terry Muir, president of Unsolved Productions and the producer of the 5-part docuseries, and I think also the director of the docuseries, has described in media interviews that the access to the defendant and her defense team was quote-unquote unprecedented. As part of the docuseries, the defendant and her counsel permitted cameras to record their trial preparation sessions in the quote-unquote war room, the car rides to and from court where the defendant and her counsels discuss upcoming testimonies and trial strategies, often commenting on, I knew they were going to work this in here somewhere, often commenting on the evidence, prosecutor, or the court. and one-on-one interviews with the defendant and defense counsels. Your Honor, they were talking about you. They were talking about the prosecutor. They were talking about the witnesses. They were talking about everybody. We need access to it. They were going to find a way to let the court know, excuse me, Your Honor, she was talking about you. I think they edited what Alan Jackson was saying about the prosecutor. I would like the rest of that car ride where they were talking about the opening statements, but I digress because now I just want the chisme. They go on to say in the 5-part docuseries, the defendant again makes inconsistent statements with previous statements she has made to law enforcement, witnesses, and most revealing to other media reporters during other voluntary interviews. For example, defendant now claims that she unequivocally saw John O'Keefe enter 34 Fairview and admits to consuming large amounts of vodka and being significantly impaired. That's not exactly what she said. She did not say she was significantly impaired. Those were not her words. I wish they would just grab the direct quote. She indicated that she had been drinking and that she was impaired. She does indicate that. It goes on to say her position, even within the 5-part docuseries, wavers from a claim that she remembers every detail from January 29th to admissions that maybe her memory wasn't as clear where she had been drinking. It's an awkward sentence, but yes, she does say that her memory wasn't as clear because she had been drinking. They go on to say the defendant confirms animosity in her relationship, confirms the altercation with Sullivan in Aruba, confirms her flirtatious text with Brian Higgins. Okay. So the most awkward, uncomfortable text messages to ever text message. If we have to sit through those again this trial, I'm going to die of cringe. Confirms that she was angry with John O'Keefe and convinced that John may have been cheating on her with other women who resided in the neighborhood around 34 Fairview Road. The defendant further discusses going to John O'Keefe's residence during the late morning of January 29th and mocks Miss O'Keefe's opinion that John looked like he had been hit by a car. There's a lot more to that in that interview. The Commonwealth goes on to write, contrary to representations made to the court on March 18th, the defendant admits on the March 17th aired episodes that she used an intermediary to share discovery with Aidan Carney, then with permission of her defense counsels, shared quote-unquote public information. And then the prosecutor digresses into presumption, which when the defense presumes in court, the court says, just tell me what you know. The presumptions of the prosecution say, presumably all discovery provided to the defense. I don't know what basis they have for that. When I hear shared public information, my initial response to that was like, oh, so like the filings and the docketed information, like that's what I would consider public information. If they have like evidentiary support for something else being shared, then that would be interesting to see. Karen Reed also says in that docuseries, yes, I spoke to him through an intermediary and then I had trust issues with the intermediary and just started talking to him directly. The presumption of the prosecutor is that the discovery provided to the defense would ordinarily not be deemed quote unquote public due to the investigatory nature of the prosecution with Mr. Carney. Mr. Carney then used this material to advance the defendant's narrative and direct harassment of witnesses. Again, there are pending cases regarding that against Mr. Carney. That is going through court process. So the prosecution is bringing this in to argue consciousness of guilt against Karen Reed. We're going to hear more about that down the line. As it is in this motion, I think it is fair to make a note that that is still pending court process. They go on to say Karen Reed further admitted that she spoke with Mr. Carney regularly about her case. Further, contrary to representations made to this court, on the March 18th episodes, the defendant expressed reckless indifference that the witnesses, many of whom came to the defendant's aid, have been intimidated and harassed, and the defendant stated, Jen McCabe, it's me or her. Either I'm going down, Jen, or you are. These public statements are going to be presented by the prosecution in court in the light the most unfavorable to the defendant. Can they use out-of-court statements of a defendant in court? Yes. Yes, they can. There will be arguments about the completeness of the statements, that the statements can't just be cherry-picked out of content. You can't just put one sentence in there and say, see, she said this. But that either benefits the defendant in that the things that she has said out of court, including I did not hit John O'Keefe with my car, can be allowed in without her having to testify, or the statements can come in and bite her because she doesn't have an opportunity to explain them. What do you mean it's me or her? Will this change the defense strategy knowing some more of these statements are coming in? Or will the defense lean into this in their third-party culpability and say, yeah, it is. Yeah, it is you or her. It's going to be an entirely different trial. It's a new trial, so I'm told. Again, if you're not watching the live streams of this case, I know some of you are done with this case and ready to move on with other things. And some of you are like, I've been in it for too long and now I can't look away because we're in it until the end of this next trial. It's a new case, I'm told, came up in court last week. They go on to say the 5-part docuseries is also ripe of new information. Look, I don't know with the writing. Ripe of new information previously unknown to the Commonwealth. For example, the defendant's statement that John O'Keefe exited her vehicle holding her vodka soda drink. I drink a whiskey drink. I drink a vodka drink. I drink it. Okay. Holding her vodka soda drink, that she clearly saw John's body from Carrie Roberts' vehicle, and that she pulled a small piece of glass from John O'Keefe's nose. All of this is going to come up, especially if John O'Keefe had glass in or around his face. It's going to change the way things are presented in this trial, I think. And then they go on to cite other quotes that we saw in the last motion, including the Commonwealth saying that the defendant reveals her initial beliefs in the immediate aftermath of John O'Keefe's death, stating to Attorney Yannetti and waiving any associated privileges, what if I ran his foot over, or what if I clipped him in the knee and he passed out, and or went to care for himself and threw up or passed out. So they're trying to bring up those statements again, though I think once you get into the autopsy, some of those things get ruled out in trial fairly quickly. However, I think it changes what the jury might know of what Karen Read was thinking in the immediate aftermath, but also it's clear that everyone was drinking. And so there are questions about how everyone remembers this event. So we'll see. But we know that the prosecution is pissed because they tell us so. They go on to say that during the 5-part docuseries, the defendant declares that doing this film is my testimony. I want to say what happened exactly as it happened. Quote, this trial by media strategy has repeatedly been employed by the defendant and defense counsel for over 3 years. The Commonwealth is entitled to, and justice dictates, production of the defendant's own statements, particularly as proclaimed to be, quote, what exactly happened. I think this will get turned over. How it will get used in court and whether or not the production company will fight them about turning it over is yet to be seen, but this will get turned over. If this docuseries had gotten released after the second trial, would this be coming up? Maybe, but the prosecution wouldn't have the same grounds to argue what Karen Read said because they don't know. It's really hard to establish relevance that Karen Read said some shit when you don't have the shit that she supposedly said. So this coming out right before the second trial is going to change the way that the prosecution can seek this information. They might never have been able to get to it had this not aired. But now that it's aired and now that those statements are out there, the prosecution is going to run down every media statement Karen Read has made and then decide if they will use it in court or not. Will that allow Karen Read to get in her quote unquote testimony to different outlets and still not have to testify? Or will it be statements without explanation from her that is more damaging? We're going to have to wait and see, but there is going to be more evidentiary fighting over these statements. I think initially that the discovery will get turned over to the Commonwealth, but if the Commonwealth is able to use them in court and how is going to be incredibly interesting. I don't know. Is this calculation going to backfire on Karen Read? I guess we're going to have to wait and see. I would love to know your thoughts about these media interviews. If you've watched the docuseries, if you've read the interviews, what you think. And we know that what you say can be used against you. And I think Hank Brennan is taking the what you say will be used against you and will be presented in the light least favorable to you. And then it will be up to her attorneys to Try to fix that through other means. It's hard when the speaker can't be cross-examined. And remember, the defense cannot put in Karen Read's own statements. They're not statements of a party opponent. So the prosecution kind of holds the cards on this. We will see. Is that going to be enough to overcome doubt in this case? Will it not? How will the prosecution use these statements, or will they not be allowed to? Trial 2 is supposed to start at the end of April, so make sure you have the Law & Order app. And if you've not been following this on stream, there have been some really spicy moments in court. They even pissed off the nicest of all of the defense attorneys, who normally is fairly mild in court. He is incredibly patient with everything that is going on and completely lost his patience last week. And I was just like, oh gosh, this is going to get wild before the trial starts. So next week, Karen Read has another hearing. I will be covering it from the road because I will be traveling. So we will be covering that probably in delay of some form. And then, of course, the following week, we will be in Idaho for those Kohberger hearings. And I will be trying to catch up on the civil cases that I'm covering in the meantime. But as this case gets towards trial number 2, we are going to be incredibly busy. Thank you for being here. Thank you for being a Law Nerd. And I will see you in the next one. Take care of yourself. Take care of each other, and may the odds be ever in your favor. And if you would like the odds of not missing a moment in court to be increased, get the Law & Order app at lawnordapp.com. I'll see you in the next one. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law & Order app at lawnordapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here. And thank you for being a Law Nerd.